Right, good evening, ladies and gentlemen. Welcome to this public lecture, which is our second this year in our International Law Public Lecture series. My name is Mario Proulx. Please come in. I'm a senior lecturer here in the School of Law, as well as the director of the Keele LLM in International Law, and it gives me great pleasure to be able to introduce our distinguished speaker tonight. So Dr. Vincent-Joël Proulx is currently serving as a legal officer and special assistant to the President of the International Court of Justice, the highest judicial organ of the United Nations. Dr. Proulx is a Canadian national. He was educated at the University of Ottawa, where he read both common law and civil law. He then moved on to do an LLM in international legal studies at the New York University School of Law before completing his PhD at McGill University in Montreal. Dr. Proulx has held various positions in the Canadian government, including at the Canadian Department of Foreign Affairs and International Trade, and he's a barrister and solicitor of the Bar of Ontario. Now, most of you will already be familiar with the work of the International Court of Justice. The ICJ has been making the headlines over the past decade with very important decisions and opinions in politically very sensitive cases like Kosovo's declaration of independence, or the legality of the war in the Palestinian occupied territories, or just yesterday you might have heard about the very important decision of the ICJ in a dispute between Australia and Japan, requesting Japan to essentially end its whaling program in Antarctica. But I should say at the outset that this is not as an officer of the court that Dr. Proulx will be addressing us tonight, but as a legal scholar. In addition to his work as a practitioner, Dr. Proulx is a prolific writer on very diverse issues such as international law, human rights, international trade, intellectual property, cyberspace law, you name it. He's authored a very important book in 2012 called, well, wait for it, Transnational Terrorism and State Accountability. This was with Hart Publishing. And he'll soon be publishing another book on state responsibility, global security, and UN organs with Oxford University Press, of which I think he might also say a few words tonight. So we are very fortunate to have both a practitioner and a scholar of such a high caliber with us tonight. And I'm sure that, like me, you're just very excited and very much looking forward to what Dr. Proulx has to say about the issue of transnational terrorism and state responsibility or state accountability. So please join me in welcoming our distinguished speakers to Keele with a big round of applause.
Thank you very much, Mario, for that very generous introduction. I'm absolutely delighted to be here at Keele University today. I'd like to acknowledge the School of Law and Professor Proulx specifically, and the British branch of the International Law Association for arranging my visit today. And of course, thank you very much for being here. I know it means a lot to me. I know I was in the unenviable position of competing with a sunny afternoon, so I'm happy to see you here today. And of course, thank you for letting me capriciously and shamelessly plug my book. So before I start, just to pick up on what Professor Proulx was saying, just let me offer one disclaimer, because this wouldn't be a lecture by a lawyer without a good old disclaimer. So I'm here entirely in my personal capacity as an independent researcher, and I in no way represent the views of the court, the ICJ. So that's out of the way. 9/11 changed everything. Guess you must have heard that one before. Yeah, it's a bit of a sweeping statement, perhaps a bit overblown too, but has 9/11 changed everything? That's precisely the question I asked myself when I wrote Transnational Terrorism and State Accountability. The only difference is I asked that question in relation to a very important branch of international law, an area of international law, the law of state responsibility. What seems clear to me is that the events of 9/11 have drastically challenged important tenets in the global and political orders, and that the international community is seeking ways to repress and prevent terrorism through a whole range of means. Now, of course, we know that invading Afghanistan is one option. But aside from this extreme scenario, international law hosts a multiplicity of regimes and systems that can help bolster the international struggle against terrorism, and these regimes are complementary. And of course, international criminal law is now one of the most attractive such regime, especially since the advent of the International Criminal Court. But although absolutely fundamental in international law, I find that the law of state responsibility is often absent from the debate surrounding counterterrorism, and I think it can provide some solutions to that struggle, while not seeking to supplant or replace those other regimes I alluded to that remain complementary. So with this in mind, this book explores the role that the law of state responsibility, so in a nutshell, the law of state responsibility is the legal mechanism that is used to hold states legally accountable for violating their international obligations. So to look at what role that law can play in the suppression and prevention of transnational terrorism. And I think the question becomes particularly interesting and compelling and pressing, perhaps, when we recall that Iran provided certain missiles and other weapons to Hezbollah factions in their attack against Israeli citizens, or that the Taliban government provided sanctuary to al-Qaeda members prior to 9/11. So in such difficult scenarios where international criminal justice is short-circuited because of the inability to capture or prosecute suspected terrorists, it's important, I think, to think about ways in which we can ensure accountability of those governments that are involved somehow so as to fight impunity. I should also mention at the outset that the International Law Commission, a United Nations mandated body, adopted a series of articles on state responsibility in 2001. And these articles exert a rather diffuse authority, but they've been nonetheless widely cited with approval, including by the International Court of Justice. And so in sum, that document or that text provides that once an internationally wrongful act is committed, so for our purposes today, when a state fails to prevent a transnational terrorist attack, international law sets into motion a series of legal consequences, which may then translate into compensation or restitution, for instance. But let's take the earlier example of whereby Hezbollah carries out armed attacks against Israeli civilians, specifically targeting civilians. Let's say that the facts reveal that Iran financed, armed, trained, and provided instructions to the terrorist factions during their excursions. If we take that scenario, it would presumably fall within the ambit of Article 8 of the International Law Commission's text, which provides, and I quote, that the conduct of a person or group of persons shall be considered an act of state under international law if the person or group of persons is in fact acting on the instructions of or under the direction or control of that state in carrying out the conduct. So this text codifies one of the manifestations of the rule of attribution, basic rule under state responsibility, which is pretty much the normative operation that is used to connect the wrongful conduct to the official state apparatus for the purposes of establishing international legal responsibility of the state. And the Iran-Hezbollah example would thus appear, upon first glance, to be really a clear cut of classical state responsibility, where the terrorist act, let's say, could be attributed to the Iranian government, or at the very least, the state could be seen as complicit in the perpetration of the terrorist activity. However, it's not even clear that this example that I've just alluded to would successfully trigger these rules of state responsibility based on a careful reading of the leading international jurisprudence on the matter, including those decisions that have referred to Article 8 of the International Law Commission's text. So there's certainly a gap there. And unsurprisingly, not every case will be a slam dunk, and not every allegation of terrorism will be as extensive as cases involving Iran or Lebanon, for instance. In fact, far more complex scenarios emerge in countries like Saudi Arabia or Pakistan or Yemen, which are characterized by a mixture of compliance and toleration. But let's revisit the Hezbollah scenario just for a moment. Let's pretend, for the sake of argument, that Iran only supplies weapons and other military support to Hezbollah without directing or controlling its attacks against Israeli civilians, or without providing the group with any instructions. So the terrorist group operates completely autonomously and has its own distinct chain of command and hierarchy. Immediately, I think, we see that the legal basis for attribution prescribed by the International Law Commission begin to fade a little bit. We certainly cannot demonstrate that Iran directed or controlled the terrorists, nor that it had any direct influence on their operations. Responsibility is difficult to establish pursuant to the classical rules. So the inadequacy of these rules has prompted some scholars, including myself in this book, to call for the adoption of new legal standards better suited for the changing circumstances of terrorism. We know that terrorism is a polymorphous phenomenon. In exploring these questions, I place particular emphasis on the broader implications for compliance, human rights, and international relations, while admittedly attempting to strike a delicate balance between, on one hand, the dignity and the sovereign equality of states, and on the other, devising effective counterterrorism strategies. It's now clear that every state has an obligation to prevent terrorist attacks emanating from their territory and causing injury to another. This proposition stems from various multilateral agreements on the suppression of terrorism and several United Nations Security Council resolutions. But it also originates from the fundamental principle of sovereignty, which entails both rights and obligations. But I still feel that the current state of knowledge does not exhaustively address the content of this obligation of prevention, the legal mechanics surrounding its breach, and the ways in which legal accountability can be deployed following such breach. So in the book, I attempt to define the contents and contours of this obligation while placing some policy emphasis on engaging the rules of state responsibility so as to better ensure that governments comply with their counterterrorism obligations. Simply put, the United Nations Security Council has issued absolutely sweeping statements on the principle of prevention in counterterrorism context. Those statements are rhetorically straightforward, and they impose categorical duties of prevention on governments. I feel it's now up to scholars, the judiciary, and policymakers to address the enforcement options for this type of obligation through, again, a multiplicity of legal regimes, including domestic criminal law, immigration law schemes, state responsibility, and so on. So in contributing to this debate, the book makes an equally straightforward argument to the effect that international law can support a shift towards a law of indirect state responsibility for failures to prevent terrorism, as opposed to focusing on direct state involvement in terrorism, which is often very, very, very difficult to prove for a victim state, except in flagrant cases of overt state terrorism. The central argument hinges on the fact that states have a primary duty to control their national territory under international law, which also entails a need to control terrorist factions and activities taking root within their national borders. So as a result, I think we're witnessing a shift in both legal and policy inclinations towards indirect modes of accountability that are both contingent on governmental failures to act or intervene in preventing transnational terrorism, and that are compatible with recent Security Council practice. In fact, the Security Council practice almost invariably conflates the obligation of preventing terrorism with the duty of all states to refrain from supporting or harboring terrorists on their soil. As the events of 9/11, the 2007 Russian-based transnational cyber attacks against Estonian targets, or the 2008 Mumbai attacks have shown us, just to take a few examples, terrorist organizations and irregulars often operate independently and autonomously, making their connection to governments blurred or virtually untraceable. In addition, the prospect of governments waging surrogate warfare through private individuals or proxies also poses intractable challenges when applying legal mechanisms to hold states accountable for their own wrongdoing in that chain of events. But conversely, I think it's also important to note that states no longer hold an exclusive monopoly over recourse to force, as terrorist networks can wield state-like power and influence across a broad range of states and cultures and so on. And this problem is certainly further compounded both from policy and evidentiary standpoints when preparatory terrorist acts span over several territories. Who's responsible? How do you establish the chain of responsibility? So I think this signals that international legal mechanisms should be bolstered with a view to both promoting transnational cooperation on counterterrorism issues and devising efficient international responsibility schemes. Surely, states may not wield as much control or influence over private terrorist activities taking place in their territory in all cases, I grant that, thereby inheriting a more passive role in the violation of counterterrorism duties. But this by no means absolves them from the Security Council's categorical pronouncements after 9/11 and the more general obligations under general international law of prevention. And in line with recent United Nations institutional discourse and state practice, states still have an important, sometimes determinant role and place in the chain of events leading up to the perpetration of transnational terrorism. Of vital importance are the conclusions formulated by the United Nations mandated high-level panel on threats, challenges, and change in its report titled "A More Secure World, Our Shared Responsibility." And the panel states that states, I quote, "states are still the frontline responders to today's threats, and that successful international actions to reduce terrorism and halt the spread of dangerous materials all require capable, responsible states as partners. It follows that greater effort must be made to enhance the capacity of states to exercise their sovereignty responsibly," end quote. It's no surprise that the perpetrators of transnational terrorism often rely on governmental inaction, state toleration or acquiescence, willful blindness, or simply ineffective counterterrorism structures as propitious incubators for their agendas. The authors of terrorism often do not possess a fixed address. They often blend indiscriminately within the civilian populations that host them. They may operate autonomously and without much state support, if any at all. And they invariably flout international law. So as a result, human security and the protection of property are highly dependent on prevention of transnational harm, and nation states are often just better situated to achieve this objective. In that regard, the monograph, I guess, responds to a broader project aimed at enhancing state responsibility and accountability for transnational violence carried out by non-state actors without casting state responsibility as a cure-all or holistic mechanism, but rather as one of the applicable legal regimes to be harnessed with a view to stamping out terrorist networks. So the crux of the book, therefore, is that international law must be revisited so that delinquent states cannot elude legal accountability for preventable wrongs. Whether obscured by intricate information networks, new technologies like internet, the sophisticated cellular structure of organizations like Al-Qaeda, complex financial structures and systems, the level of governmental involvement in terrorism is no longer readily discernible in all instances. But the fight against impunity behooves the international community to certainly, or to ascertain the responsibility flowing from state failures to prevent terrorism, where there was clearly a duty to act. So in addressing the literary dearth, the book delivers a particularly critical analysis of the concept of attribution, the normative operation used to connect seemingly private acts to the official state apparatus for the purposes of establishing international responsibility. So when contemplated through the various examples invoked in the book, I mentioned a few at the outset, supplemented by the ICJ's, or the International Court of Justice, relevant jurisprudence, it becomes clear that the agency paradigm, because it's really an agency paradigm that drives Article 8 of the ILC, where you have this subservient agent that's carrying out the mandate of the state, that this agency paradigm and the logic of direct responsibility that underpins Article 8 of the International Law Commission's text are simply ill-suited, in my view, to respond to the threats of transnational terrorism. So in response, the book identifies a paradigm shift towards more indirect modes of responsibility under international law, a trend that is, I think, corroborated by recent state and institutional practice. And so after drawing on varied legal and theoretical influences, the study devises and prescriptively argues for the implementation of a strict liability-inspired model grounded in indirect responsibility, a model that is both policy-driven and context-sensitive. And this model is advanced with a view to enhancing state compliance with counterterrorism obligations, first and foremost, but also to shifting the focus to prevention and the promotion of multilateralism and transnational cooperation. So in particular, I devise a two-prong approach. On the one hand, I suggest that sanctuary states that harbor or support terrorists should automatically be made internationally liable for failing to prevent transnational terrorist attacks. On the other hand, and bearing in mind the abuses, the potential abuses inherent in this approach, a host state would then have the opportunity to exculpate itself on an ex post facto basis. So based on this rationale, a completed terrorist strike invariably establishes a prima facie finding of liability against a sanctuary state, and correspondingly shifts or transfers the burden of refuting that responsibility onto it. So this second prong obviously entails a thorough examination of important collateral questions, such as logistical concerns, the protection of developing countries, the promotion of transnational cooperation on counterterrorism issues, the expansion of multilateral structures, the problem of failed or ineffective states, the promotion of fairness and legitimacy in international relations, and the safeguarding of state dignity or reputation on the international scene, which is more important than we think. So when exploring these challenging questions, I try to remain mindful of the importance of elaborating a discourse that is sensitive to the realities facing the developing world. A deficiency in logistical capacities or capabilities required to crack down on terrorism is not invariably synonymous with a lack of political will, or nor does it necessarily translate into the endorsement of the terrorist cause or the endorsement by the governing apparatus. More importantly, in devising workable models of international responsibility, the monograph also distances itself from the relatively uncontroversial 9/11 precedent as the dominant paradigm of transnational terrorism and investigates perhaps more complex situations of mixed compliance and toleration that I think have profound implications for the law of state responsibility. So the ensuing analysis not only delves into the situations prevalent in Lebanon, Yemen, and Pakistan, but also sheds light on on new modes of transnational violence, such as cyber terrorism, and also draws parallels from the field of international environmental law. Therefore, I think the most challenging areas warranting further intellectual exploration are not cases of overt or direct state participation in terrorist activities, but rather reside in more subtle instances of governmental acquiescence, toleration, and willful blindness to terrorists operating within state boundaries. And so the book takes on a number of examples and case studies in that light. So it turns out in that context that the state's responsibility in the case of infringement of an international legal norm may result not only from controlling irregular units, but also from the lack of sufficient control over them or failure to act or negligence, including the failure to comply with the legally binding resolutions of the Security Council. Much of the post-9/11 literature on international law and terrorism has dealt with issues of human rights or jurisdiction over suspected terrorists, with little emphasis placed on state-to-state normative conflicts extending beyond the use of force. Use of force is still very much in vogue. So the book seeks to make a contribution in light of that literary gap. And so on the whole, I think that this project casts state responsibility as a partial political legal solution to transnational terrorism, while critically investigating the difficulties associated with self-judging, auto-qualification, and the quantitative and qualitative exercise of devising legal consequences following the violation of the obligation to prevent terrorism. I'll come back a little bit on self-judging in a few moments. So I feel that the book has significant policy relevance for a variety of reasons that I addressed in part. And at times I think it makes unabashedly policy-driven arguments through a legal prism. In many ways, therefore, law becomes a translation mechanism for international politics and serves as a catalyst for vindicating specific policy objectives that are rooted, for instance, in the Security Council's post-9/11 dialogue, with a particular emphasis on prevention and early detection of transnational terrorism and its root causes. So in sum, if I had to summarize, I think the book was written with one simple yet very challenging purpose in mind: to strike a sensible balance between, on one hand, the principle of non-intervention into the affairs of states, which is absolutely sacrosanct under the UN Charter, and on the other hand, the pressing need to root out transnational terrorist networks, which is an exceedingly important objective in the UN's institutional dialogue and beyond. But when I finished writing this book, which really deals with the mechanics of state responsibility and calls into question some of its underlying assumptions, I remain bothered by a lingering question. How are international obligations enforced and state responsibility implemented when unilateralism is not a viable option? Under extant international law, responsibility flowing from an internationally wrongful act is typically actuated and ultimately implemented through interstate mechanisms. This means that a state that has been wronged by a violation of international law committed by another state can pretty much unilaterally adopt countermeasures to compel the wrongful state to comply with its obligation or to repair the initial breach. So in practice, this type of enforcement takes place in the context of disparate and sometimes asymmetrical diplomatic relations. So the state seeking to enforce international law against another state thus possesses a large margin, a large degree of latitude in devising unilateral countermeasures subject to proportionality and other restrictions, but also enjoys the same latitude in auto-qualifying the different aspects of the dispute and ultimately in self-judging the violation of international law and its consequences. Ironically, I think, countermeasures essentially boil down to the suspension of the performance of an international obligation by one state to induce compliance with the international obligation by another state. So I think a cynical view might cast this mechanism as using illegality to fight illegality. However, the former type of illegality is tolerated and excused under the current international legal system. Yet, I'm sure that everyone in this room can imagine countless scenarios where, for political or practical reasons, this kind of enforcement would just not work. So what happens then? Inherent in the debate of whether state responsibility can play a role in the suppression and prevention of terrorism is the idea, a bit controversial, of institutionalizing the implementation of state responsibility. A sort of system of coordination to monitor and ultimately sanction violations of international law. I'm currently exploring, as Professor Proulx mentioned, these issues in a new book project titled Institutionalizing State Responsibility, Global Security and UN Organs. Leaving self-help remedies and unilateral countermeasures aside, in my view, the question of whether state responsibility for failing to prevent terrorism could be implemented through existing United Nations organs warrants serious consideration. I think we must conceive of alternate methods of implementing state responsibility if we are truly to empower the obligation of prevention and suppress terrorism, as the Security Council mentions it, all means at our disposal. So surely that would include the UN and its organs. And in terms of UN organs, we may certainly turn to the United Nations General Assembly and the International Court of Justice as viable fora in which both the rules of state responsibility and counterterrorism could be engaged. But while the General Assembly has undoubtedly made significant advances in the promotion of counterterrorism agendas and strategies, I think its potential contribution remains severely limited because of the jurisdictional constraints built into its statute. Sorry, that goes for the court. For the General Assembly, little mistake. For the General Assembly, I think it's just because it can only issue non-binding resolutions. Of course, the court's decision would be binding, but only between the parties appearing before it. So I think in that respect, yeah, the ICJ would be a viable forum, if not a good one, but there's these jurisdictional constraints in place which severely limit its potential contributions. And I'm really skeptical, to be honest, that two states would bring a case about terrorism prevention to the court, but that's just political pragmatism. I don't know, perhaps I'll be surprised down the road. So what does that leave? The Security Council, in my view. And I think that the connection between Security Council practice and the creation, interpretation, and application of the rules of state responsibility remains largely underexplored, especially in the field of counterterrorism. So in this new book project, I attempt to remedy this deficiency with a view to advancing the discourse on this front and leading to hopefully the formulation of potential deterrence models. So starting from the premise that state responsibility can play an important role in suppressing and preventing terrorism, the question of enforcement remains rather elusive. And so I argue that the Security Council can play some role, sometimes determinant, but just some role, in shaping and applying rules of state responsibility in counterterrorism contexts. I think that international terrorism and the legal tools to suppress it epitomize a truly sui generis phenomenon in that they offer a unique opportunity for the Council to advance the law of state responsibility without overstepping its more fundamental and intrinsic boundaries, according to its mandate. So since there's no compulsory judicial recourse under international law to implement state responsibility, I'm convinced that the sine qua non means of enforcement in this context resides in the concept of reciprocity. And I would add that reciprocity, or the fear of incurring international responsibility, might in fact help neutralize asymmetrical power dynamics in the global legal order in some cases, and then induce governments to comply with their international obligations. The whole refrain of reciprocity goes something like this: states comply with their obligations because they expect the same behavior from other states. That's simple. But it's not really that simple. I think that this sometimes utopian concept of reciprocity is by no means infallible. Its compliance pull starts to wane in the context of terrorism when dealing with inefficient or willfully blind governments and recalcitrant states, or especially when the interstate implementation mechanisms envisaged by the International Law Commission become inefficient themselves. So in that regard, the thrust of my policy argument is that an institutional structure would seek to fill this gap and regularize these situations. So in my view, the Security Council appears on its face to be best suited for the implementation of state responsibility, as the UN Charter devolves vast powers to it in safeguarding collective interests, all under the organizing principle of international peace and security. For one thing, the particular scheme of powers devolved to the Council, which involves recourse to coercive measures under Chapter 7 of the UN Charter, potentially offers a wide range of options in ensuring compliance with international obligations and in implementing state responsibility. But I can hear the criticisms already. I certainly concede that the Security Council's process is not without its problems, be they grounded in structural reservations, political misgivings, or broader concerns over legitimacy. All fair, I think. Yet, surely in some instances, the Security Council's multilateral process can or should be preferred over unchecked unilateralism. It's a query that I have. But I would suggest that Security Council action can implicate state responsibility in at least two ways. First, I think it's possible to argue that the Council interprets certain aspects of state responsibility practice in specific fields. For example, several measures and sanctions imposed by the Council can undoubtedly be construed as particularly binding manifestations of the state responsibility derived notions of guarantees or assurances of non-repetition or satisfaction. These are all remedies under the law of state responsibility, and I think there's definitely a rapprochement, conceptual rapprochement that can be done, made between those and the Council's action. Notable examples of this practice, all in the context of Resolution 687, following the invasion of Kuwait by Iraq, include, and these are no small matters, the reaffirmation of the international obligations of a given state, the disarmament and subjection of a state to weapons instructions, and the devising towards the delineation of an international border. And this all stemmed from the recognition by the Council of Iraq's international liability, legal responsibility for the invasion and the occupation. So second, and more controversially, I think there's various doctrinal currents that stand for and against the proposition that the Security Council sometimes spearheads certain law-shaping incursions into the realm of state responsibility. Regardless of one's stance on that debate, however, I think it remains fair to contend that Security Council decision-making often at least informs the unilateral implementation of responsibility by states in relevant circumstances, along with the application of these secondary rules of responsibility, so the remedies that are provided for under the law of state responsibility. And Council resolutions can also be particularly instructive in determining the legal characterization of a given situation, or act as a benchmark in ensuring the legality of requests or countermeasures adopted by states. So drawing from state responsibility logic, the Council often calls upon a wrongful state to cease a given behavior that is synonymous with a threat to the peace, and that simultaneously amounts to the violation of an international obligation. It did so in many contexts with regard, for instance, to the invasion of Kuwait by Iraq, as I mentioned, terrorist actions in support of terrorist groups by Libya, and genocide and humanitarian law violations in Rwanda, and so on. The Council even imposed an obligation of reparation upon Iraq in the context of its invasion of Kuwait, thereby mirroring an essential component of state responsibility repertoire in its decision-making. And I think in this, when you study this topic, this resolution 687 was monumental because it embodied the disciplines of responsibility along with the corresponding ideas of reparation and return to legality, which are cornerstones of state responsibility. And similarly, in the early 80s, the Council pronounced on the international responsibility of Israel in the aftermath of its bombing of a nuclear reactor in Iraq, and imposed upon it an obligation to compensate Iraq. And in recent years, Iraq has undertaken steps towards securing and obtaining that compensation from Israel. Although its findings can sometimes be predicated on a prior declaration of responsibility, the main stumbling block of this new project, I think, it's probably fair to argue that the Security Council does not directly rule on the question of state responsibility per se, rather framing its reasoning within the furrow of its Chapter 7 powers under the UN Charter. However, in my view, there clearly exists a significant conceptual and practical overlap between Chapter 7 objectives and the suppression of terrorist acts, which are almost invariably tantamount to threats against the international peace and security. So at the outset, I think that the very notion of terrorism, or many of its manifestations, engages Chapter 7 considerations. And I think also that in recent years, the Council has increasingly tackled terrorism by invoking state responsibility-like language, thereby signaling that the seemingly indelible chasm between that body of law and the restoration of international peace and security can blur on occasion. And I think a cursory review of the Council's post-9/11 resolution making on counterterrorism issues will also reveal that it's replete with responsibility expansive language along the lines of what I've quoted earlier. In several resolutions since 2006, the Council has referenced the responsibility to protect, which is a controversial emerging norm of international law, according to which states must protect their populations from mass atrocity. So in my view, this practice, these short examples of practice, evidence an enhanced focus by the Council on responsibility models grounded in states' control over territory in which unlawful behavior has taken place, and the corresponding duties to prevent and exercise sovereignty responsibly. I would submit that these observations are integrally transposable to the context of terrorism. So that's the new book in a nutshell. But ultimately, at the end of the day, this all brings us back to my initial query. Has 9/11 changed everything? So the answer I've come up with is this: it's complicated. Surely the answers are complex and multifaceted, but by the same token, it would appear that the initial query was more complicated than initially thought. So perhaps the question or the query should be reformulated to, has 9/11 changed anything? So the answer to that question, as regards international law, will hopefully come into focus in the coming years as state and institutional practice develop further. But in the interim, it seems clear to me that more equitable and effective narratives on state responsibility can only result from an inclusive process, supplemented by ongoing policy dialogue at domestic, international, and transnational levels that gives due regard to some practicable middle ground between legal and political dimensions of international relations. I thank you for your kind attention, and I welcome any thoughts or comments you may have.
Thanks, Vincent Joël, for this terrific and very stimulating lecture. We now have 15 minutes for questions. I would simply ask those of you with questions to stand up and speak up so we can clearly hear your questions, and Vincent Joël can answer them. So anyone with questions?
I would like to ask, you said the Council imposed the obligation on Iraq to compensate Kuwait and on Israel to compensate Iraq. Since the U.S. invasion of Iraq, what has the Council done so far to ensure that it compensates Iraq the same way?
I would argue not much. That is a valid point, and that's the problem with power politics that underpin the Security Council, and that's definitely one of its major limitations. I can't say that I disagree with you. This is the problem. It's a bit of a selective approach based on the inequitable power dynamics within the council. So I think that's a real problem. And some people, Marcelo Cohen, for instance, have studied this call for greater reform of the Security Council, where this veto power is outdated and so on. And some people argue, like Cohen, that we should just focus on the accountability of the Security Council, so developing actually the responsibility of the Security Council. Now that's a whole other kettle of fish. How would you implement that? Would it work in practice? But I think there's some serious shortcomings, definitely, to these kinds of issues that you raise.
Let's be fair.
By sending that message, then, does that not imply that they're applying compensation selectively based on who they're choosing to be worthwhile or worthy?
Yeah, that's exactly what it implies. And that's exactly how state responsibility works as well, because the alternative in the ILC text is a system of interstate implementation. So you have a powerful state that will essentially unilaterally impose sanctions, countermeasures against the other state. So is that better, or is a multilateral process? I think they're both flawed. Definitely a judicial recourse or a third party. I think Kelson had spoken about that. The institution of a third party, objective, impartial institution. I mean, the ICJ could fulfill that role, but it just doesn't because there's no compulsory jurisdiction. It doesn't have that role as the Supreme Court of international law. So I think those are real concerns as well.
Hi, thank you for your time. I just wanted to ask, in terms of national terrorism, I know we're talking about transnational terrorism, but in terms of state accountability, how would international powers such as the UN try to implement measures to help states deal with national terrorism in order to tackle the bigger problem of transnational terrorism?
Right. Well, there's several aspects to that answer. I think I'll try to give a few. Number one, if you step outside of the UN system, I mean, like the US has injected billions of dollars into Pakistan, for instance, to help with counterterrorism. It also has troops on the ground. Of course, allegedly, admittedly, it wants to exert a bit of power over the policy making as well. So we have to, I think, remain pragmatic and realistic about that. The UN itself, in the wake of 9/11, in Resolution 1373 by the Council, it is this resolution I was talking about, adopted vast measures, for one, I think it was the first time in its history where you had obligations, essentially setting an obligation of customary international law on all states with no geographical limits or temporal limits. So it did that, and then in the wake of that, accompanying that development, it set up the Counterterrorism Committee, which then in turn developed all these sort of guidelines and virtually fill in as you go template legislations for states to better fight the scourge of terrorism. But at the end of the day, it's all about, I think, a transnational cooperation, and that's the key thing to emphasize. So that would be just the main answers to the question.
Thank you for your lecture. So basically, I have two questions. The first one, do we have any difference if we use the term international terrorism instead of transnational terrorism? And my second question is, maybe our problem nowadays, we give so much power for like the US, for them to use the term terrorism for more than that purpose. So maybe in the first place, that's for revenge terrorism. But after that, maybe the political purpose or economic purpose, and how like the cost like ICJ or UN consider about this problem when we use the term terrorism for different purposes.
Right. Yeah. Well, I think both questions raise a whole score of interesting issues that could be dealt with in a dissertation, I'm sure. Just to take a sip as a stall tactic here. Yeah, the definition of terrorism. Well, first of all, transnational versus international. I think. Well, let me make just one main point about definitions. One of the stumbling blocks in dealing with terrorism, there's two stumbling blocks. One is a definition. One terrorist is another person's freedom fighter. These these classical adages. For me, the definitional controversy over terrorism has very little to do about the state responsibility, because at the end of the day, because it's such a political process, the state launching the accusation will auto-qualify. That's one of the problems with this. Where, for instance, in Nicaragua, US, we discussed this in Professor Proulx's class earlier. The U.S. was held accountable for supporting some of the actions of the Contra rebels against the Sandinista government in Nicaragua in the 80s, and Nicaragua itself was qualifying the rebels as terrorists. Of course, the court dodged that question. So it's really in the eye of the beholder. But to go back to your question about transnational versus international, international, of course, in the 70s, you had these the dominant sort of model of terrorism was counter transborder strikes in the context sometimes Israel-Palestine, context of protracted conflicts and that kind of stuff. Now, because you have preparation over several territories, we saw that in 9/11. I mean, several territories were involved. I think the term transnational capture is a little more the sort of diffuse structure of terrorist cells. But the other stumbling block that goes to the heart of your question, I think, is when you write a book like this or conduct a study like this, you won't escape some sense of methodological arbitrariness, because you can't sum up terrorism. There's one dominant model. There's, it's just impossible. There's large-scale terrorism, as we've seen on 9/11 now. The big problem is cyber terrorism, cyber warfare, that kind of stuff. So at the end of the day, I sort of sidestep the definitional problem, because whether you're in the Security Council, if you're in the Security Council in a multilateral process, then there will be some kind of constituency of conscience. If you're trying to disarm Hezbollah, for instance, the Council has made a lot of pronouncements that Lebanon has a duty to do that. If you're going more with the interstate model of implementation, then you have the problem of self-judging auto-qualification. So the US accuses, let's say Ecuador accuses Colombia of not preventing FARC. Colombia accuses Ecuador of not preventing FARC rebels from launching transborder action and all that kind of scenario. So at the end of the day, the definitional stance is not that important. We had Rosalind Higgins, a brilliant British lawyer who was the president of the ICJ, who wrote essentially defining terrorism is, terrorism is a term of pure political convenience. It's old wine in new bottles, so it just really captures prohibited conduct that strikes at private or public targets. So I transnational in the title was just to sort of capture this broader social phenomenon where you have really several territories that are involved. And by the same token, if you go to the International Law Commission's text, there's an Article 47.1 where, when you have several preparatory acts that contribute to a final internationally wrongful act, there's a scheme that is envisaged for that, and that really poses problems in environmental law, which is not unlike terrorism, where do you put a dollar amount, on this country because it failed to prevent these terrorists from entering, or this country because they were planning, is it the last state from which the attack is launched? So these are kind of the issues I'm grappling with, and I think everybody has to grapple with, and it's really hard to adopt blanket solutions across the board. That's why I think you need to favor a context-sensitive, fact-specific kind of approach to these matters.
We've got time for one last question.
Yeah, I think these are very valid points. In this book, state terrorism, the way I envisage it in this book, is when there's direct support of states. We had that in the 80s with the PLO. We certainly have that with Hezbollah and Iran and Syria before this whole mess in Syria happened. So I try to exclude those because I wasn't interested where there's so much of a direct connection, because I think really the future, well, first of all, if you look at the case law, the jurisprudence, I don't know what would qualify, because it seems like there's very stringent standards and we shouldn't focus on the direct. I mean, the genocide case in 2007 is a good example of that, where there was a genocide, but there's no attribution, so there was perhaps a compromise within the court to say, well, there's a failure to prevent genocide. Some people see that as a political compromise within the court. I see that as, no, it's good, let's focus on prevention. That's the idea. You want to make states responsible, and that's kind of the vantage point I approach this problem with. in terms of terrorism between states, so I excluded state terrorism in that respect. And the first part of the question was state terrorism in Iran? Oh yes, U.S. support. That is a hard question. Actually, I think that would make a wonderful advisory opinion request to the ICJ. Is it legal to support rebels when there's a legitimately elected government in place and so on? I would possibly exclude that from the purview of this specific analysis, because I'm really focusing on private, non-state actors that are not fighting in the context of an internal civil war, for lack of a better term, and so on. Because state responsibility, it's a bit slippery when you don't want to make too many sweeping statements about self-determination or if people are fighting as a I'm not saying that's what's going on. I just say, if there's a situation of resistance or something like that, it's where the analysis becomes a bit murky, I think, yes.
All right. So I'm just going to conclude by thanking Vincent Joël again for being here today, thanking the School of Law and the International Law Association British branch for making this event possible, and of course thanking you all for taking on your own time to come and attend this event. We very much look forward to seeing you to our next public lecture, and in the meantime, have a wonderful evening.